So we begin with the raging public debate over the meaning and implication of the Supreme Court judgment that recognizes the right to form an association of lesbian, gay, bisexual, transgender and queer, that is LGBTQ community. The Council of Imams and Preachers of Kenya and the Kenya Christian Professionals Forum have said they're joining in the growing condemnation of the Supreme Court decision, saying which they say would erode Kenya's family values. And as Citizen TV's Ayub Abdikadir reports, religious groups continue to express outrage over the contentious judgment.
It is a judgment that has stirred outrage, particularly in the religious circles, with sharp condemnations dominating Sunday after worship remarks and now flowing into the new week. Christian and Muslim leaders have closed ranks over a judgment that effectively extends legal recognition of the LGBTQ community in Kenya.
If this association is so as to spread, popularize, and bring about more and more people into this kind of actions and behavior, then we call it out as evil and must be addressed as so.
Sisi wa Kenya tushikaneni mikono sote pamoja, dini zote, kwa sababu hili si masala ya dini tu, ni masala ya dini na masala ya culture yetu.
The judgment also appears to have confounded constitutional experts, with some suggesting that the Supreme Court will ultimately have to review its own decision.
The court has done what they did based on their interpretation and analysis of the law. So that means there is a problem with this legal analysis, and there has to be a way of resolving the issue.
You can go back to that very Supreme Court for review and request that instead of the 5 judges who determined, we have the whole Supreme Court, which is a bench of 7 judges, said to have a relook at that determination and to come with different, determinations.
People who identify as gay or lesbians or intersex or bisexual enjoy the broad framework of the law, just like those who identify as heterosexuals. The only minimum limitation, the only significant limitation is that they cannot formally be joined as man and wife.
Kenya's constitution, promulgated in 2010, is considered one of the continent's most progressive, complete with a robust Bill of Rights. But the LGBTQ question remains a touchy crossroad for both the law and the people.
The criminalization of same-sex marriages, which is already made an offense under Section 165 of the Penal Code, is part of the discourse to promote the realization that people of different sexual orientation do actually exist, and that we do not need to punish people for identifying with one orientation as opposed to the next.
We are concerned that you have attempts to change our laws contrary to the view of majority of Kenyans, and then introduce behavior and conduct that attacks and damages the family, attacks and damages family values, and therefore the social fabric is affected.
So we are going back to the Supreme Court to remind the Supreme Court that in as much as we keep talking about human rights and fundamental rights, those rights are limited under Article 24 of the Constitution. And among the limitation is that you cannot enjoy your right to associate, to pursue what the law prescribes to be illegal.
The Supreme Court judges had last Friday, in their majority judgment, held that a decision by the lower courts to deny members of the gay community in Kenya their right to register as a non-governmental organization was discriminatory. The judgment followed a close to a decade-long court battle by the LGBTQ community for right to be registered as a non-governmental organization. Ayub Abdikadir, Citizen TV, Nairobi.